Welcome viewers to the Personal Injury Law Show. This is our 11th season, new set, new everything. Viewers, my name is Tony Carbone, personal injury lawyer of over 25 years experience. With me tonight I've got John Carancis. Good evening, John.
Hi Tony, hi viewers, it's great to be back, Tony.
And a very senior lawyer, David Phillips. Good evening, David, how are you?
Good, thanks. Hi Tony, good evening viewers.
Viewers, tonight we'll be talking about quite a few issues. The biggest issues, a decision that was handed down the full court of the Supreme Court just recently. It affects all workers in Victoria. But before that,
Tony, let's see what's in the news.
In the news there's been a lot of stories, but the first one, fellas, is about the payouts to students at schools.
It's a lot of money, Tony.
$6.7 million in the last 12 months. Some of the things that, some of the biggest payouts, David, were students struck by a person playing football, $1 million. Student falling, slipping during athletics, $402,000. Student falls, slips, $400,000. Student struck by a moving object during sport, $340,000. Do you think that's a lot of money, Dave?
No, look, I don't think that's a lot of money. School's got a duty of care and they've got to look after the students, and if people suffer injuries, they should be compensated, Tony.
John, it sounds like they're pretty big payouts, especially in the public liability arena.
They are, Tony, they are, Tony. It looks like anyone that is being injured at school is straight away going to see a lawyer. Now, that's good in one sense. Everyone's got their entitlements, everyone's got their rights. But at the same time, there has to be balance there, doesn't there, Tony?
Oh, of course. David, is there a special duty on the schools?
Yes, Tony, there's a special duty on the schools in the sense that because the children, the students at the school are minors, there's a higher duty of care because there's a special relationship between the school itself and the children. So, yes, it is a higher duty of care, Tony.
And John, the payouts, I think they're high because in the work cover area, to get that sort of money, you've got to have some fair income injuries.
Fair income injuries, Tony. Look, with the footballer receiving $1 million, he must have ended up as a quadriplegic.
A brain injury.
Exactly. Now, in the end, the duty is on the school to take care of these children. They're under their care. So, Tony, if they've breached that duty, well, then that's it.
Just curiously, is the duty of the employer similar to the duty of the schools?
It's similar. It's a non-delegable duty of care. That means, viewers, that basically the employer and the school can't say, no, someone else is liable and responsible for schools, for example, students, or for the employers, the employees. They are responsible, and they can't say someone else is responsible.
Let's move on, viewers. There's another story about seaside disaster foretold. The authorities in Port Melbourne were told that there's a lot of jet skis skiing too close to the foreshore where there's swimmers.
Every summer, Tony.
And there's been a couple of deaths and some serious injuries. David, is there any liability on the council?
Yes, because it's their duty to take care of the beach and the foreshore, so they essentially should be looking after the swimmers, and if people are encroaching right on the shore in terms of jet skiing for the swimmers, that's dangerous and they'll potentially sustain injury. So in answer to your question, Tony, yes.
And John, what are the rights of the, well, this particular person died, so what are the rights there?
Look, the dependence, there's a dependency claim, but really it depends on, I mean, if you're just suing the jet ski driver, well, as you know, Tony, firstly, there may not be insurance, they may not be insured for that type of event. And secondly, if they're a man of straw, as in they don't have a cent to their name, well, you're wasting your time.
I would have thought that you'd join the council in this one because
I think so.
They were aware of jet skiers being close to shore. There's plenty of witnesses to verify that fact.
It's going to be tough, isn't it, against the council, isn't it, Tony?
Yeah, but I'd still go against the council as well.
Oh, for sure.
And just Dave, what about family members for nervous shock? They can sue, can't they?
Look, potentially, Tony, they can sue because if you say, for example, a jet skier hits a swimmer and you're sitting on the shore and you see your child struck by the jet ski and you suffer a psychiatric condition, then that's a consequence and you can sue, Tony.
Okay, let's keep moving. There's another story of a young girl that was burnt by a DVD plate that exploded. John?
Shocking case, Tony. It looks like it's a portable DVD player. It's exploded in her face. Shocking burn injuries. Again, there's a claim against the manufacturer and maybe the retailer, Tony.
Okay. And Dave, you could probably sign a trade practice to that, couldn't you?
In terms of
It's a
the actual
defective
DVD,
product.
it's a defective product and it's caused injury to this young child. So yes, you could sue for that.
But under the Trade Practices Act, it's a lot stricter in terms of what you can and can't recover. So you'd have to assess it pretty carefully. You probably need a lawyer to really assess this for you.
Oh, for sure, yes.
Yeah,
Definitely.
And just the last story I want to go to at this stage is a lady who's gone into hospital and she's miscarried after she's sent home 6 times by the hospital. She bled and she lost the baby.
Shocking case, Tony, and we've talked about this time and time again. The hospitals, they've got a duty of care to these people, that patients that attend hospitals, they want their help and they're being sent back. Now, of course, the hospital's always saying that there's not enough resources, not enough staffing levels, and you know that goes back to the Victorian government. But at the same time, Tony, there's a duty there. The hospitals can't send these people away.
It sounds like a resourcing issue, doesn't it, Dave?
Yeah, look, definitely there's a resourcing issue, but in this day and age, one would think with radiology and CTs and MRIs and ultrasounds and all those sort of things, that things would get diagnosed properly and not to go to the hospital and be turned away not once but twice but 6 times. That's a disturbing scenario.
And this particular lady had a lot of previous problems, so they should have been extra careful with her. She had a lot of procedures and everything else.
Look, she should be seeing a lawyer, that's for sure.
Viewers, now let's go to the topic of tonight, which is the to do with workers. There's been a recent Court of Appeal decision that's probably the most significant decision in the last 20 years.
Tony, I think it's the preeminent case in work cover legislation in Victoria. It's a matter of Georgopoulos, Victorian Supreme Court of Appeal, Justice Beach, Justice Forrest
And Osborne.
and Justice Osborne. A unanimous decision, Tony. Literally, the court, in essence, has held, and we'll go into detail, viewers, as to how it's held this, but it's held that basically, in a common law damages claim for lump sum compensation for pain and suffering and economic loss, a worker can rely upon all body parts that you are injured with, that you suffer injuries from. Not just the one body part that you've been granted a serious injury ticket for, and we'll go into exactly what that means because it is a complicated topic, but all body parts, and it's fantastic.
Well, David, it's the most momentous decision in probably 20 years. The Accident Compensation Act was changed on the 1st September 1985, been significant changes since, but in the time I've been practicing, which is at least over that period of time, this is the biggest one I've seen. Viewers, we've got to go to the sponsors break, so stay tuned, and after the break, we'll go to